I'm speaking with attorney Brendan Quinn about workers' compensation. Brendan, is there any time when a worker can sue their employer when they're injured?
Generally, an injured worker cannot sue their employer. The entire workers' compensation system was created so an injured worker would not have to go to the trouble and expense of suing their employer to get the benefits to which they were entitled. When they created the workers' compensation system almost 100 years ago now, the right to sue your employer was taken away. So even if your employer or a co-employee's negligence causes your accident, you cannot sue them. There are a couple of narrow instances where an injured worker can sue their employer. The most prominent of those is where the employer fails to secure workers' compensation coverage. In that instance, the injured worker would have the option of suing their employer or pursuing a workers' compensation claim to what they call the uninsured employers fund. Or if the injury is due to an intentional act, that is, the employer attacks one of his employees, you could sue the employer in that instance.
What's involved in filing a workers' comp claim?
Well, it's generally a two-step process. You give notice to your employer that the injury happened, and then you file a claim with the Workers' Compensation Board, which is the state agency which administers workers' compensation claims.
How long does it take before you usually start receiving workers' comp benefits?
As a general rule, it would take about 2 to 3 weeks. If an individual suffers an injury at work, they have to notify their employer, seek immediate, the appropriate treatment that they need, medical treatment. And once that medical report gets to the insurance company indicating that the individual is disabled, the clock begins to run and the insurance company has to respond within a certain amount of time, which generally would take about 2 to 3 weeks to get a check if you were disabled from the date of accident forward.
What should a person do if they get notification that their workers' comp claim has been denied?
Well, you're going to need a lawyer at that point because there is going to be a trial essentially at the Workers' Compensation Board. The denial would come in the form of what they call a C7 or notice of controversy. The insurance company, once they get notice of the claim, has two options: accept the claim or deny it. The comp board will set up a file, and that will result ultimately in a hearing being held, and there will be a trial where the injured worker would have to testify. There might be some testimony from other lay witnesses from the employer, and there might be some medical testimony as well. But you should get an attorney as soon as you get that notice of denial, because you cannot go through that process without an attorney. You'll be at the mercy of the insurance company, who will have their own attorney there.
What's the process for a workers' comp appeal?
Well, the litigation would generally take 6 months to a year. That would not be the appeal process. The board has instituted more recently what they refer to as the rocket docket, which is supposed to speed things up. But generally, it takes 6 months to a year for a controverted case to wend its way through the system, and then you would get to appeals after that.
Are all work-related injuries covered by workers' comp?
Generally, yes. The only time that an injury at work would not be covered when it is due to an intentional act, such as when someone intentionally injures themselves or gets into a fight with a co-employee, or that could be covered if the fight arose out of the work environment or some issue at work, or if the person is intoxicated or under the influence of drugs. But even those instances, you might get compensation benefits because the insurance company would have to show that the injury was due solely to your intoxication. But almost all injuries at work are covered by workers' compensation.